Hey, and welcome to Employment Hour in 30. I'm your host, John Scholes, co-host Lior Samfiru. Anytime you want to get a hold of, it is 1-855-821-5900. We'll repeat that number throughout the show. EmploymentHourTV.ca as well. That is a great resource for all things about what we talk about on the show, and also to find where you can listen to one of the radio shows, which we will refer to, and get some phone calls later on in the program. And always, it's a staple, severancepaycalculator.com. More discussion on that is coming up. So we got an exciting 30 minutes here, chock full of information. You want to stick around for the entire show. If it's your first time, we talk about employment law and how things affect you in your workplace, whether you're an employer or an employee. You might be the boss, you may be a subordinate, a minion, doesn't matter. It all affects you. We'll get to that as well. Lots of stuff on the show. We always start Mon frere with the week that was. How's it going with you?
I think that's French.
Sort of.
Okay, well, thank you, John. And it's great to be back. It's great to be talking about employment law and workplace rights. It's been a very busy couple of weeks, actually. My office spoke with a lot of people. My gosh, I don't know, maybe there's something in the water, but a lot of questions have been asked of me about people's rights, dealing with losing your job, getting your job, discrimination. So I welcome that. If you're watching us right now, you have questions, there's a good chance we may answer those questions right here on the show today, but if we don't, call me at the office. Let's talk. There's no bad questions. And of course, give me an opportunity to try to solve your problems and to help you in your situation. Now, John, week there was where I talk about a couple of situations, or at least one situation that came across my desk over the past few days. Well, I actually received a few calls this week, again, maybe something in the water,
right,
from people that have worked at a hair salon or places where they do hair, cut hair. And in both of those situations, people really lost their jobs, but didn't get anything near what they were owed. In the first situation, the person was treated as an independent contractor, right, which is, again, nonsense. They worked just for this salon. They went there every day. They worked. They got the clients from the salon, and then they went home. They had a regular job. But by the way, this is quite common with hair salons, where the people working there are quote-unquote independent contractors. But guess what? They are employees. And when this person lost her job, she was owed full severance as an employee. The other situation was someone that was let go as an employee, but the company said, well, we're a small company, so we don't have to pay severance. That's just for big companies.
Right.
And this person called me, and of course she was owed severance. Because remember the rule, we've talked about this on the show before. Big company, small company, it doesn't matter. You still get your severance because it's based on your age, your position, and the length of your employment. So I wanted to bring this up because you're going to see so many times, if you're throughout your career, situations where someone gives you the wrong information. Maybe they call you an independent contractor when you're not, or they try to tell you they don't have to pay severance because it's a small company. Big misconceptions. Don't believe that. Any questions? If it doesn't seem right, if it doesn't pass the smell test, it probably is not right. Get on the phone, call me, email me. Let's find out what the truth really is.
Now, she called you, which was a smart move. Say she hadn't caught the show, hadn't listened to a radio show at all, didn't know about you, and said, you know what, I guess so. They've got a payroll less than $2 million. I guess I don't get anything because I'm an independent contractor. We spoke about this, and you said she's around 40, 45 years old, been there for about 18 years. If she'd walked away with nothing, how much would she have been missing? Based on ballpark.
Probably about 18 months pay, 18 months pay. So can you imagine, she's told she's not getting anything, she's not owning anything, when in fact she's owed a year and a half worth of income. That's huge. And for the most part, when we're talking about severance, the difference between what people are offered or not offered and what they should be offered is not $1,000, $2,000. Hey, that's a lot of money, $1,000, $2,000. I'm not trying to diminish that. But we're talking about people that are oftentimes shortchanged for tens of thousands of dollars or even more. So for this person, yeah, 18 months pay. Size of the company doesn't matter. If you're an independent contractor, guess what? If you have a regular job, you're probably an employee. Very common situation. So again, reach out, call, email. Let's talk.
EmploymentHourTV.ca, again, a great resource to find where you can catch our weekly radio show, which has been going on for about 6 years, give or take, a little more now. So we take a lot of phone calls on the show. We like to cherry pick some of the good ones, play them back here, and get your commentary on them, Lior.
I've been employed with a large employer for 8.5 years, and through a restructuring, they gave me my walking papers last week. I'm 65 and a half years old. I was a manager, and they're offering me 32 weeks. And I've been listening to your show a number of times, and that seems pretty inadequate to me. They gave a date that I have to get back to them by.
A big bowl of wrong there.
It is. And some people that may have not heard our show, either our TV show or our radio show, may think, well, that sounds right. He was there for about 8.5 years. They gave him 32 weeks. That's like 7.5 months pay. That's not too bad. But let's remember here, John, the factors that go into assessing how much severance are age, position, and length of employment. Now, this gentleman is 65 years old, so he's older. That's going to increase the severance. He's also a manager, so it's a more senior position. Again, that's going to increase the severance. So I can tell you that after 8.5 years, he's going to get a lot more than 32 weeks pay. Rather than me just tell you how much he gets, very easy for me to do, let's actually plug that information into the severancepaycalculator.com website so everyone can see at home how that works. So he's a manager, 8.5 years of service, 65 years old. Severance calculator correctly assesses him as being owed 14 to 16 months pay. Now, John, remember, he was offered 7.5 months pay, so he's owed double what he was offered, double. So that's very important. So I don't know what his income is, but whatever his income is, you can assume that doubling it would mean extra few tens of thousands of dollars for him. That's how easy it is. And many people would have thought, hey, that doesn't sound too bad, when in fact he's owed double. There's a lesson there for everyone. If you're let go, you got to use the severancepaycalculator.com website. You got to get some advice, because otherwise you could be owed a lot more than what you've been offered.
Thing is, though, with double the amount of severance which you just calculated there, that might give him the option to sit back and say, you know, at 65, maybe now I could afford just to ride off into the sunset and retire. Whereas before, at his age, not easy to get another gig, and he's got half that severance coming to him. It could be panic mode, right? Either
retire or at least take the time that you need to find a proper job. If you're stressed for money, like, I'll take the first job that comes around because I'm desperate. On the other hand, if you have the severance, it gives you that time that you need to find a job that makes sense for you, that you can be in for a while. That's what severance is designed to do, to give you that cushion to take you to the next stage of your life.
Help at employmentlawyer.ca is the email to reach out, and 1-855-821-5900. Let's get to another phone call from the radio show, and we'll move on from there.
I had an accident. I was working in a warehouse. I slept, and then I twisted my knee. I got a surgery, and then when I went back to work, because I was working on a heavy machinery, and because all those vibration and everything else that I was receiving, I couldn't do my job anymore. And they were forcing me back to work. And then at the end, I couldn't do anything, and I just quit.
Oh, that's a tough position, man.
It is, and I remember this call. We got that on our radio show. Well, let's be very clear. If you have an injury or any really medical condition that limits your ability to do your job, the company has to accommodate you. It's as simple as that. It doesn't matter if the work or if the injury happened at work or if it happened while you were climbing mountains somewhere out of the country. It doesn't matter. If you have a medical condition, an injury, a problem, a physical issue that prevents you to do the work, the company has to accommodate. Now, all you need to trigger that accommodation is something from your doctor, something that says, here's the accommodation that he needs, whether it's lighter duties, whether it's other modified duties, providing you help, giving you the ability to work from home sometimes, changing your hours, whatever it is the company has to do. They can't simply say, we're not going to do it. Well, in this particular situation, based on what he said, the company refused to accommodate. They just told him, you have to do your old job. He couldn't do it, so he quit. But the fact that he couldn't do it, the fact that they didn't accommodate, does not mean that it's a resignation. It means that that's really a constructive dismissal. He only resigned because the company did not meet its legal obligations. Right. So not only is this a situation where he's owed severance because he didn't resign because he wanted to, he is potentially also owed human rights damages. When a company fails to accommodate, that's a human rights violation, that's illegal. So there's a lot for this person that he can do, and a lot of entitlements that he has, and I wanted to bring that up today, because if your employer refuses to accommodate, if you need help to do your job because you have physical limitations, maybe it's because of age, that's fine too. Your employer has to accommodate. If they don't, that's illegal.
A lot of terms to get in the employment world. We talk about them on this show and the radio show as well. The non-competition clause. Some people don't ever have to worry about it. A lot of people do. The non-compete is what we call it. Let's talk about it. What is it?
It is a lot more common these days. You know, when I started practicing law some 15 years ago, I didn't see it as often. Certainly not for every kind of day regular positions. Right now, many employers, probably most employers, ask employees to sign non-competition obligations. Now, a non-competition obligation, as the name suggests, is a term that you would sign either in an employment agreement or a policy that says that if you leave or are let go, you cannot work for a competitor for a period of time. That may also specify the geographical location, whether it's in Toronto, whether it's in Ottawa, anywhere in Canada. So the period of time, the geographical location. But for many people, that could be a huge problem. If I've worked in an industry for my whole life, and now I can't work in this industry for 2 years, that's a huge issue. What do I do then? So we want to talk a bit about that and give people the right information about non-competition obligations.
So you mentioned it's more common now than it used to be when you first started practicing. So if you took 50 employment agreements now, back then might have been a few, how many would you see? Half of those?
So certainly I would see it now for all agreements if it's a more senior position. Okay. But even for people that are not in a senior or managerial position, I'd probably still see that in 75% of agreements. So it's very common. So chances are if you're accepting a new job right now, senior, not so senior, you probably will see a non-competition obligation in it.
So if you're COO, fiduciaries, that's almost guaranteed to be in there?
Almost guaranteed. Wow. Almost guaranteed. For managers, executives, absolutely, you'll see that guaranteed.
The next question about the non-compete is enforceability. Is it enforceable?
Well, so this is where it gets interesting. For most people, a non-competition obligation is not enforceable. It's not. Our courts have said that we don't like things that prevent people from earning a living. Okay, so because of that, for 95% of people, it's not enforceable. What it is enforceable is for people in very senior positions, fiduciaries, people that are so important to an organization that if they're going to leave the company, it's going to hurt their former employer. It's going to damage it in a big way. For most people, you're watching us right now, our courts have said that even if you signed it, it's still not actually going to be enforceable by the company.
But someone's listening going, okay, then I'll just ignore it.
And that's the natural reaction. Oh, good, I know it's unenforceable, so who cares? I'm going to go work wherever I want. Well, not so fast. The reason I say not so fast, because the question shouldn't be, is it enforceable? The question should be, is your former company going to try to enforce it? Because if your former company is going to try to enforce it, guess what's going to happen? They're going to sue you. They're probably going to sue your new company. And you're going to be involved in a very long, expensive, and complicated legal battle. Now, at the end of that legal battle, you're going to win because, again, it's not enforceable. But it's still going to cost you a lot of money. It's going to be very unpleasant. So it's not going to be a really good victory. So my rule of thumb is very simple. If you sign it, you have to be prepared to live with it. Right. It's as simple as that. So do not sign a non-competition obligation unless you're prepared to abide by it. If you just ignore it, you run the risk of being sued. Not a pleasant situation. You have to take it seriously. And if you can't take it seriously, you want to, or if you can't abide by it, then talk to your employer, negotiate, deal with it rather than just ignore it.
You want to get a hold of Lior anytime. The rest of the team at the firm, 1-855-821-5900, talking about the old non-competition agreement in your contract of work. Okay, say I have one. I've been let go or I want to leave, and I want to be a good boy. I want to abide by the contract, but I got an employer who really wants me. What do I do? Can I negotiate it out? Can I talk to somebody?
So the first thing you want to do is try to address it when you first start a job. So if you can start a job and you have a non-competition, talk to your employer and say, I've been working in this industry for my whole life. I don't want to be out of this industry. I'll agree not to take your clients. I'll agree to keep things confidential, but please don't try to prevent me from working somewhere else. If you did sign it and now it's time to leave and you want to work for a competitor, be honest with your employer. Approach them the same way. I'm not going to go after your client. I'm not going to hurt your business, but don't prevent you from working somewhere else. With most employers, if you approach them that way in an honest way, in a forthright way, they're going to be reasonable and you can negotiate terms and they can relieve you or release you of that non-competition obligation. The problem is if you're not going to do that, if you're going to simply ignore and go work across the street, that's when the employer is going to get suspicious. That's when they're going to get concerned. And at that point, you may find yourself with a lawsuit.
Well, the flip side of that coin, of course, is the employer. So what does an employer do to protect themselves, say, from employees leaving and going across the street to competitors?
I would say for employers, really only use non-competition obligations for your most senior people. For those people that you really, really can't imagine working for someone else because it's going to hurt you. For everyone else, use non-solicitation obligations. Have terms that say that if you leave, you can't go after our clients, you can't go after our other employees, you can't go after our suppliers, and you're going to keep things confidential. That's the best way to protect your business. If you're going to use a non-competition obligation, be reasonable with it. Yeah. Don't say you can't compete for 2 years anywhere in Canada. Maybe limited to 6 months within a certain geographical area. The more reasonable the non-competition obligation is, the more likely it is to be enforced. So remember, employers are employees. You can use that, you can be smart about it, but for employees, you have to be very careful. If you're just going to sign it, you cannot ignore it later on. You have to address it, be honest with your employer, and try to work out a solution that will avoid you being sued.
Now, one more thing before we wrap up this topic. The non-solicitation, which you touched on, that is enforceable, correct?
Yes. So unlike a non-competition obligation, a non-solicitation obligation is enforceable. And a non-solicitation obligation simply says that if you leave or we let you go, you're not going to go after our clients, customers, employees. Those are enforceable for the most part. Employers should use them, and individuals should be prepared to abide by them.
Now you know, non-competes. More information on the way. We'll take a short break. 1-855-821-5900. Help at employmentlawyer.ca. And the severance pay calculator is on the way after that break. Right here on Employment Hour in 30.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact. The labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
Hey, welcome back to Employment Hour in 30. If you're just joining us, I'm John Scholes, your host, co-host Lior Samfiru. We talk about employment rights and the workplace, where you spend about 1,800 hours a year. So this is important stuff. And an important step in knowing all this is SeverancePayCalculator.com, an amazing tool. We are getting close to 600,000 people almost that have used this.
Crazy.
And been enlightened, right? So give us some details on it, pal.
Yeah, it is insane for me to think about that. 600,000 people.
I'm in.
Yeah, me too. That have used it over the past few years. It's a lot of people, and the reason they've used it is because it's so easy to use and it gives such helpful information. SeverancePayCalculator.com. Again, the address couldn't be simpler. SeverancePayCalculator.com. The place you go to if you lost your job, you're staring at that severance letter, and you're trying to make some sense out of it. Wait a second, they've offered me 6 weeks' pay. Is it good? Is it bad? Am I owed more? Once you go to SeverancePayCalculator.com, you're going to be asked 3 questions. What is your age, your position, and the length of your employment? And then you find out how much you're actually owed. And then you know whether that offer is good, if it's bad, or if it's neutral. So it's easy, it takes seconds, it's completely free, and it gives you that information that you need to have so that you don't find out later, oh my gosh, instead of 6 weeks, I was owed 18 months' pay. Very common situation, by the way. And then it's going to be too late to do anything about it. SeverancePayCalculator.com. Even if you haven't lost your job, even if you're worried or curious, check it out right now. Who wouldn't want to know how much severance they're actually owed? So take a look and see what you're owed.
You know what? Easy to talk about, but until you take it for a spin, you don't get it. So I'll throw a scenario at you here, and you can run it through the calculator. Robert, 58-year-old data analyst, 24 years on the job, earning about $68,000 in salary. Termination papers were left on his desk and contained a 20-week severance pay offer. 20 weeks. Is that a fair amount? Does the fact that the business is owned by an American company change the result?
Well, let's start with the American company first. Obviously, if you work here in Ontario, you're owed severance based on Ontario and Canadian laws. Doesn't matter where the company is headquartered. Now, a lot of American companies have a hard time understanding that. They believe that you should be getting the same severance or be treated the same way as they do back where their home office is in the United States. And that's very different because in the United States, they have something called employment at will.
Yeah.
What that means is you can be let go pretty much without any compensation, any severance, just goodbye.
You don't want that.
Well, that doesn't mean anything in Canada. We don't have that. It's illegal. So oftentimes with American companies, you have to educate them a bit. Say, well, wait a second. We have things that are different here in Canada. So let's talk about Robert and his specific situation. So he's been there for 24 years, 58 years old, data analyst, and of course he was offered 20 weeks pay. I can tell you right now, spoiler alert, that's a terrible offer.
Totally.
But let's actually put it into the SeverancePayCalculator.com website and see what that gives us. So if you see, we plug that information. It's right there on the screen. The end result is that he's owed 18 to 22 months. Not weeks, months. And he was offered 20 weeks pay. Now, depending on his compensation, and my understanding he was making $68,000, that's a difference of somewhere between $78,000 to $100,000.
More than a year's pay.
Oh my God, that's a lot of money. And by the way, this is a true story. We didn't make it up for the purposes of the show. We took a scenario, we changed the name to protect the innocent.
That's it.
But it's a true scenario from something I had in my office. That's an example right there why you use the severancepaycalculator.com site. So check it out.
EmploymentHourTV.ca is the place to go as well to catch our weekly radio show, or at least find a station where you can do so and listen to that, and podcasting as well. We'll get to another call from the radio show, and I know you'll want to make some comments on that one too, Lior.
Company has been sold. I drive to it locally. Literally, it's within about a mile. And it's been sold to another company, but it's a 3-hour round trip to get to the new location, and they're not paying any compensation for that. What I'd like to do is look for something local, but I want to be able to get unemployment insurance while I do that, as I've paid into it.
3 hours, that's half a day.
That's
half a work
huge.
day.
Can you imagine? So this is easy. Honestly, it's easy. When a company moves, doesn't matter if it's a new company that's sold or the same company, if you're now going to have to commute an extra 3 hours in this case to get to work, that's ridiculous. That's, of course, a huge change to the terms of employment, which means this is a constructive dismissal. And by the way, John, even if the change was less than 3 hours, frankly, even if it was an extra hour a day, that would still rise to the level. Absolutely. It's a big deal. Now, interesting here is this person called us asking about employment insurance. He wanted to know whether you would qualify for employment insurance. Well, the answer is yes, he would, but he also gets severance. Yep. I think he assumed that because he decided to quit himself, that he wouldn't get a severance, but hopefully only employment insurance. But he gets severance as well, because he didn't quit because he didn't want to work there. He quit because they changed the terms of employment, and that happens when there's a constructive dismissal. If your employment terms have been changed, demotion, pay cut, relocation, change of hours, change of shifts, yep, or even the compensation structure has been changed. If any of those things happen, not all of them, any of them, you may have the right to treat your employment as being terminated, get your severance right now, and yes, you would also qualify for employment insurance. If that happens, though, before you quit, before you hand in your keys and say, I'm out of here, call me, let's talk about it. The devil's in the details, but that's the option that you have.
And that number again, 1-855-821-5900. We'll take a short break. Get to lots more. In fact, how to deal with harassment from your boss is on the way. Employment Hour 30 continues. Hang on.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back. Employment Hour 30. Still lots more to go through here in the next few minutes of the show. 1-855-821-5900 to reach out, contact Lior, member of the team. And there's always severancepaycalculator.com. That is the first place you go when you have a severance offer in front of you. Or maybe you just want to find out, if that ever came down the pike, what would I be owed? That's where you want to go, and you can follow up. There is a contact button at the bottom of the calculator. Don't have to use it. Calculator is absolutely free, by the way. If you wanted to pay for it, you can't. That's how good you are since you started this thing 600,000 people ago. But the radio show, EmploymentHourTV.ca, is the resource to find a station to listen to that and the podcasting as well. Get a ton of phone calls, as I mentioned before, so we'll get to another phone call from the radio show, and Lior, you can dissect it.
My daughter, she's a manager. She's been there 10 years. She is being abused verbally very badly by the director of the company, everybody is afraid of this woman. She's at the point now where she's so stressed out. She sits in the car in the morning and doesn't want to go into work. She has a box of pay stubs of the last 10 years where she's never been paid overtime. She can't take it anymore. What can she do about that?
Tough call. It's not only harassment it's the boss.
It's the boss. What do you do? It's the boss. It's a tough situation. What a terrible place to be in, where you have to work yourself up in the car just to get to work. It's not obviously.
Devil's wear Prada.
It's terrible. No one should work in that situation, and that's the key. No one should have to work in that situation. You should not be harassed. You should not be mistreated. You should not be in a poisoned, unhealthy, uncomfortable work environment. And if that happens, the law says, well, wait a second, you have the right to get out of there because you shouldn't have to suffer in that situation. We talked about constructive dismissal. Well, that's another type of constructive dismissal. If you're actually being mistreated, harassed, well, you don't have to work there anymore. You can leave with your severance. Now, if there's a way for her to resolve it internally, someone to speak to HR and owner, then she should try to do that, see if the problem can get fixed. She should file a complaint internally. The company has to investigate and take measures to fix the problem. If that's not possible, because it's the boss himself that runs the operation that's harassing her, or she's tried and nothing's happened, then it's time to treat that as a constructive dismissal. Not only, of course, is she owed overtime, as in this question, because she didn't get paid, potentially there's human rights damages, but of course she gets severance. Question always becomes, well, how much severance?
Yep.
Well, let's plug that again just to make the point into the severancepaycalculator.com website, and let's see what that gives us. So in a managerial role, 10 years of service, I picked an age, 41, seems like a nice age. And guess what? Someone in her situation gets somewhere north of a year's pay, 12 to 14 months pay. So that's what a constructive dismissal in this situation would give her, that severance, potentially more, potentially human rights damages, there's outstanding overtime. The message, of course, is very simple. If you're being harassed, if you can't resolve it internally because there's no way to resolve it internally, well, it's time to leave. Don't be sitting in your car suffering every day. Don't be going off on a medical leave, disability stress leave. That's not going to be healthy. Let's leave. Let's quit the job. Let's get our severance and move on to a different one. But of course, as I said before, do not quit without speaking to me first.
Another place for you to go to ask questions anytime is terminationquestions.com. You ask your question, will be answered by Lior, a member of his team, quite quickly. There's been literally thousands of questions asked there. Yours might be there with a full answer in it, so have a look first. If not, type it in, and away you go. We'll get to one from terminationquestions.com. Says, my boss put me on a temporary layoff because business is slow. I don't think there's any chance of being called back to work. I think they're just hoping that they don't have to pay me severance. What do I do?
I've seen that many times where the company is putting someone, quote unquote, on a temporary layoff. They don't believe that they're going to call them back. They just hope that they'll find another job and never hear from them again. Avoid paying severance, save money. Well, let's be very clear here. A temporary layoff in itself, for most people, is a termination. So just by virtue of the fact you've been put on a temporary layoff means you can treat that as a termination and get your severance now.
Nice.
You don't have to wait to see if you get called back to work. The day you've been put on, quote unquote, on a temporary layoff, you can treat that as a termination. Now, if you've been laid off before and you allowed it to happen, you may have a problem.
Story.
You do, because you've created that precedent. You've created that history that it's okay to lay me off temporarily. That's now a term of employment. So you don't want to let that happen. With a temporary layoff, I always say, no, we don't want to accept that. If you accept it, it can happen again and again and again, and that's no way to work. So no, especially if you know your boss is not going to be calling you back to work, why wait? Why wait for 3, 4, 6, 8 months and see what happens? Let's treat that as a termination right now. Let's get your severance. Call me. I'll help you do that.
We'll slide another one in quickly. Again, terminationquestions.com before we wrap for another day. It says, my employer let me go, but is now saying, of course, that I resigned, which means I don't get severance. What are my options? What do I do?
Well, that's actually a problem, because if you had a discussion with your boss and they verbally told you you're fired and you're out of there, but you don't have anything in writing, the boss, the company, if they're inclined, they could lie and say, no, you quit. Yeah. So what I always say in a situation where you've been let go and you don't have a letter, obviously if you have a letter of termination, it's not a problem, because we know you have a letter that says you've been let go. But if someone lets you go verbally and there's a concern that they may say later that you quit, send them an email right away, literally the moment you leave there, saying, confirming that you let me go today. You do that, you protect yourself. Not a day later, a week later, you do that right away. Create that record yourself. Make sure that they know, I'm not resigning. You're the one that told me I'm out of here, so okay, goodbye. At that point, we can get your severance. I never like to get into a fight as to whether someone resigned or was terminated. And for most people, that's not an issue. Most people get a letter in their hand that says they've been terminated. If you don't have a letter, send an email, confirm that in writing. That's the way to do it.
In that scenario, it doesn't change the severance amount at all. It has no bearing on that whatsoever.
Absolutely not. If you lost your job, you are owed severance. Again, the factors are age, position, length of employment. Again, big company, small company, part-time, full-time, works just the same, John.
So again, one more time before we leave, go through that severance pay calculator again, nail it into their brains, because it's got to be there, right?
It really has to be there. It really has to be automatic. If I lost my job, severancepaycalculator.com. You grab your smartphone, grab your tablet, grab your laptop, whatever it is, and check it out. It's free, it's anonymous, it's easy to use. And if you use it, you've essentially guaranteed yourself that you're not going to lose out on the money that the law says you should have Don't let that happen to you. SeverancePayCalculator.com.
Done for another week. You want to reach out, phone call always works still. At this day and age, 1-855-821-5900. There is employmenthourtv.ca. That will give you a way to catch the podcast and our radio shows. And finally, emails as well. help@employmentlawyer.ca. Till next time, it's been the Employment Hour in 30. Catch you again.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.